Good afternoon, everybody. My name is Chris Justice. I'm an associate with Samfiru Tumarkin, and as always, I'm here today to hopefully answer as many questions as I can, things relating to employment law. So if you've got your questions, definitely get them in now while I'm here, whether it's to do with maybe something you're wondering about before getting into an employment situation or arrangement. Maybe you're going through some difficulties or having some issues during the course of your employment itself, or maybe you've been let go and you're wondering perhaps how much severance you're owed or whether or not the package that you were provided was fair and reasonable. Whatever it may be, as I say, get your questions in and I'll do my best to answer them within the time that we've got for today. But before I get into some of your questions, as I always do as well, I just want to talk about some recent topics. Actually, in this case, I was going to first chat about a case that came across my desk the other day, something that I hear a lot of, and it had to do with medical accommodations being refused by the employer. So I spoke with an individual. He had been working at a company for many, many years. And during those years, his shift was sometimes day and sometimes night. And he would do sort of an equal split in terms of his shifts from day shifts to night shifts. And this was going on, as I say, for many, many years without an issue. Then, as it so happened, this individual sustained an injury and he had to take some time off work. He had to go off on a medical leave of absence. And so he did that. He went off on a leave of absence. After speaking with his doctor, he had come to the conclusion with his doctor that he needed to take certain medication. And the medication that he was taking sort of affected his ability to work both the day and the night shifts. So his doctor, after speaking with him, wanted him basically to only work night shifts in order to accommodate the medications that he was taking. So he got a doctor's note and he provided that note to his company as far as accommodation request is concerned, looking to work the night shifts only for at least a few months until his doctor advised otherwise. But his accommodation request was rejected. The employer basically said, no, we're not doing this. This is going to be an issue because everyone else has to do both shifts, and to give you only night shifts for a period of time would be unfair. People are going to get angry. They're going to get mad. So we're not going to do it out of an issue of fairness. And this, as I say, comes up a lot. A lot of employers think that they need to treat everyone the same, even if somebody has a specific medical issue or an accommodation request. They still try, in a lot of cases, to treat everyone the same across the board, when in actuality, they need to generally accommodate employees who have medical restrictions, especially those who have provided notes from their doctors that speak to, in this gentleman's case, the fact that they can only work certain shifts for a certain period of time. And employers, as much as it may be annoying or a burden to them, they still need to find a way to make it work. It doesn't matter if other employees don't like it or there's some perspective or perception of unfairness. They have to accommodate. They have a legal obligation to accommodate. And if they don't accommodate, in a lot of these cases, employers are going to be seen as having dropped the ball in terms of their accommodation obligation. And that's going to open up a big can of worms, because now the employee is being told they can't work any shifts unless they can work all of them. They've got the medical note, and now they're just left in the lurch. They're left in limbo, and they're without any pay. And this is, in many, many cases, a breach, as I say, not only of the contract that the employee has with the employer, but a breach of obligations they owe to that employee under certain legislation. So when this gentleman spoke to me, I told him that I would send the company a letter to remind them of their obligation and to let them know that as long as you are seeking appropriate accommodations, they need to accommodate. And if not, then this gentleman could be seen as having been effectively terminated by his employer. And given that he had worked for several years, the severance that would be owed in the event of a termination of this nature was going to be upwards of almost 2 years of pay. But not only that, the fact that the employer failed in its duty to accommodate the medical restrictions also opened up that can of worms I mentioned, as far as creating human rights violations. And so not only now would this employer be on the hook to have to pay out this employee's full severance, but it's also on the hook now to have to pay potentially human rights damages, bad faith related damages on top of the severance. And so it becomes a whole huge issue above and beyond just severance for the employer. And fortunately, in this gentleman's case, when I got involved and sent a letter on his behalf, the employer did eventually end up accommodating him. But there are a lot of instances where even if I get involved, the employer still refuses to accommodate. And those that are listening right now that might be in a similar situation to this just need to know that they aren't without recourse, that they do have options, that if they cannot negotiate a return with their employer, that they're well within the rights to potentially pursue a lawsuit, commence civil action against this employer for all those damages that I mentioned. And I think the issue, as I mentioned, is sort of when employers believe that it's too much of a burden or inconvenience to accommodate someone. And what people need to know is that even if it is a burden or even if it's an inconvenience, even if it costs the company some extra money to accommodate one individual here or there, that's not going to be enough to have the employer avoid its obligations. The law expects employers to incur some degree of inconvenience or of burden or financial strain to accommodate people. And it's only after that the employer can show that there's a huge burden, and I'm talking a massive one, that maybe they can refuse to accommodate somebody. But in 99% of the cases, this simply is not enough. There is not enough of a burden, and the employers are on the hook for a lot of money being payable to this employee. So if you're in a situation like this gentleman was, you definitely want to give us a call. You want to talk to us before having any major communications with your employer, because as I say, they do drop the ball, whether it's intentionally or through ignorance, but it becomes a huge issue. And there are tens of thousands, if not more dollars, potentially on the table for someone, rather than just walking away from it and getting nothing, or rather than just sort of waiting around in limbo, hoping that the employer is going to do the right thing. So I thought, as I said, I'd bring this case to those that are listening, the attention of those listening. As I say, just because it is unfortunately something that happens far too often in my case, but you definitely want to give us a call if you're in that situation. I'm going to go into some other topics I wanted to talk about. But first, before that, I'm just going to get into some of the questions because I do want to make sure that I answer everything to the best I can. So I've got one question in from Steph on YouTube who's saying that they've been told that because they work for a non-for-profit organization or charity, that they don't have the same entitlements to severance, and they're wondering if this is true. It isn't true. In fact, in the vast majority of cases, if you're working for a not-for-profit or a charity, at the end of the day, you're working for a company of which you're an employee. And if you're a non-unionized employee in particular, which is where I specialize in, and you've been let go for a not-for-profit or charity, you are still going to be generally owed the same severance as you would if it was some other organization. Sometimes the non-for-profit or charity organizations are, I'll say, a bit tighter with their money in terms of the severance that they want to pay out. But that doesn't mean that from a legal perspective, your entitlements aren't the same. And so the same considerations will play a part. There really isn't anything all that special in the charity or non-for-profit realm, other than maybe practically speaking, they don't want to release as much money or part ways with as much money to you. But otherwise, the same factors will go into effect. So things like how old were you at the time you were let go, what your position was with the company, how long you were with the company, and how long it would reasonably take someone in your situation to find another job that would be considered comparable after you've been let go. So Steph, if you're watching, definitely give us a shout. At the very least, we can set up a consultation with you, kind of go through all the main factors to consider, figure out what your severance entitlements are, figure out what exactly the company's opposition or objection to paying you severance is, if it's something specifically, or if it's just them saying, we're a charity, we're a not-for-profit, we don't have a lot of money. It could also depend on certain things there too. But for the vast majority of people, you're still going to be looking at the same entitlements. So there shouldn't be any question in terms of that. But thanks, Steph, for your question. I've got another one in from Stephanie on Facebook who's saying that they recently went to small claims court regarding a wrongful dismissal. And they are saying that they did end up settling, but out of court, which for the most part is what usually happens. A lot of people may have to go that necessary evil of commencing a lawsuit, but statistically speaking, the odds of that lawsuit going all the way to a trial, very, very low. Just for those listening, you're thinking, okay, if we start a lawsuit, does that mean I'm going to go to court or anything? Likelihood is actually no, it's not. It just usually means that you're going to have to go through a certain number more hoops through that litigation process before you get to a point where you settle out of court, which is seemingly what happened in Stephanie Bush's case. But Stephanie's saying that they signed a release about a week ago to settle. Again, another very common thing, whether you settle with a lawsuit or without a lawsuit, you're going to be generally asked to sign a release that allows the company to have the peace of mind to know that you're not going to come after them later on. So they don't have to be looking over their back. We'll give you this money, and in exchange, you're going to go away essentially and abandon the lawsuit that you have against us. So that part's fairly common as well. But Stephanie's asking, how long does the employer have to pay the settlement? And if they don't pay, can I take them back to small claims for unpaid monies? So usually in the release or in a document that is attached to the release, it will list out the terms of the payment. So it might say something like the parties have agreed to settle the case based on, say, $10,000 being paid to the employee. And standard practice is that money, whatever that money you settled for is, usually gets paid out within 30 days of signing the release and sending it back to the company. So you may first want to look at the release or at the minutes of settlement to find out if there is a time frame, but generally that's the time frame. Sometimes employers might extend it out 45 days, maybe in some cases I've seen 60 days. But generally, if you don't have the money by then, there could be an issue. And, Stephanie, you're mentioning what happens if they don't pay. If you've got a release or a document that you've signed that says they're going to pay X amount of dollars by a certain day, and they breach the terms of that settlement, then you absolutely can go to court and basically have the court enforce that settlement. And if required, you may be able to get a court order from a judge that says, we're demanding you pay this money within this certain time frame. And if the employer then still fails to pay the money, then that employer could be on the hook not only for the severance or whatever settlement was negotiated, but there could be additional damages for breaching a court order, which the law does not, take lightly. But there also can sometimes be terms in the settlement that say if the settlement is not paid out, certain monies are payable. But if not, you can still take them to court, get the court to enforce an order to pay those monies. And if you had to spend extra money, say in legal fees, to have to do all this, to go back to court, to get the court to enforce the order and all that, or enforce the settlement, you can also, I think, justifiably ask that the court also offer you an additional amount of money, let's say for legal fees or for the inconvenience of having to go through those hoops on top of the settlement funds. So you signed about a week ago. I would say normally within 2-3 weeks from that time, the money should be coming in. But if not, you definitely want to follow up with the company. And if there is a significant delay, I absolutely do tend to recommend to my clients anyways that they go forward, they try to get that court order and try to get some additional money for having to go through those hoops. So hopefully, Stephanie, you don't have to go through that. But there is recourse for you. And so, yeah, not only can you get that, but you could potentially get some more money for the hassle and for the legal fees incurred going down that route. So hopefully, fingers crossed, it works out. But if that ends up being the case, I would chat to whoever your legal counsel is that was dealing with the claim or with the case, and ask them to sort of push it forward if need be. Got another one in from Ishtiak on Facebook, who's saying that they were let go from a truck driving position, Canada, US. So it seems like they crossed the border somewhat often, but they were employed in Canada. And they're asking or wondering whether or not compensation for truck drivers is different and what sort of entitlements they have. So in general, as far as, it comes to your potential full severance rights, the difference isn't really there. So a truck driver could work for a provincially regulated business within the province of Ontario, say, or a truck driver could also work for a federally regulated business, maybe across Canada. But at the end of the day, if they're let go, they're still going to be owed severance. And in the vast majority of cases, that's still going to also be based on those main factors that I mentioned earlier when it came to Steph's question on YouTube, as far as how long you were there, your position, your age, how long it takes you to find another job, what kind of available employment that would be considered comparable there is. So there shouldn't be really generally any huge difference in terms of severance or in terms of your entitlements. So it may, again, depend on what exactly the employer is saying to justify its position. But otherwise, like most employees, you're going to have the potential, depending on how long you were there and those other factors, to still get upwards of 2 years of severance. But thank you for your question. I've got another one in from Delia on YouTube, who's saying, if an employee is laid off and then finds a new job at a different company and lets the former coworkers know of the openings at the company, can the old company pursue an action against you? No, they cannot pursue an action against you if all you're doing is advising people of an opening at a new company. That you're not really doing as long as you're not doing anything beyond that, there shouldn't really be any issue. Really, you're just letting people know of potential opportunities out there. Now, if on the other hand, you are let go from a job and you join another company, and then you reach out to all your former coworkers and you sort of tell them to join the new company you're with or to leave the old company and come join the new company, sometimes that can be an issue as far as soliciting employees of that old office or that old company you work for. So it kind of depends on what messaging you're conveying, what exactly you're saying. But if it's just a matter of letting people know about opportunities out there, there's really no issue. It just becomes more of an issue when you're trying to, as I said before, solicit employees or maybe enticing employees to leave their former employer and join up with you. Sometimes that can breach, in some situations, not all, but sometimes that can breach a non-solicitation clause that might be in a contract of yours. So it may also come down to whether or not you have signed any employment agreement with the old company that talks about what your obligations are after you've been let go or after you've left. So in some instances, there's non-competition clauses, although in Ontario, those have been banned. But then in other instances, you have non-solicitation clauses, which usually say that you can't, reach out to former employees or staff and, try to recruit them, so to speak, and tell them to leave the former employer. So that can become a bit of an issue sometimes if the company finds out. But otherwise, I don't really think there's generally going to be much the old company of yours can do if it's just you letting people know of other possible opportunities. But thanks, Delia, for your question. I think it's a good one that's not asked too much and doesn't come up much. So it's good to raise it. I've got another one in from Ash on YouTube who's saying that they work as a maybe a superintendent supervisor for a group of apartment buildings. And part of their compensation is living accommodations, but they're told that this isn't included in any severance offered. And they're wondering if that's true. So if that is part of your compensation, then in most cases, you want to make sure that is included in your severance. So sometimes people will have a car allowance or some sort of monthly allowance they get, or they'll have living accommodations and they rely on those living accommodations. So when they lose their job, now all of a sudden they don't have that as a benefit, and that can cause a lot of issues for them. But it is still legitimately a part of their compensation or remuneration with the company. So whether the company gives you those living accommodations throughout the notice period or extends that, or perhaps the company can give you an extra chunk of change in lieu of those accommodations to sort of make up for that. You want to generally, as an employee, make sure that everything is being considered, especially in the early stages. So, you're being let go. A lot of times companies just pay out your base salary. Maybe they pay out your benefits, but then they forget things like commissions or bonuses or pension or like I say, car allowance, vehicle allowance, and living accommodations can definitely be included in that umbrella. So it's somewhat typical for employers to say, at least initially, that this isn't part of the package. But in a lot of cases, that's something that you may have to negotiate with them on, whether it's with yourself or with a lawyer in general. But definitely, if it is a big part of your compensation or remuneration with them, and you're relying on that, especially if you don't have accommodations elsewhere, then absolutely that should be something that you stress. And if you need any help with that, definitely give us a shout, because we deal with this thing day in, day out, and we can help negotiate a package that includes everything in totality, or as much as possible, rather than just maybe half of this or a piece of that, but nothing else. So it's a good question, Ash. But yeah, it's not surprising to be told that. It just becomes a different issue when usually legal counsel get involved. I got another question in from Nadia on YouTube, or sorry, on Facebook, who's saying that they're a small business owner, and they've recently noticed that one of their staff had some odd behavior, and some inquiries were made, and they found out that this employee was high, I guess, on some sort of drug during his shift, and also distributing weed to other staff members. What are my legal options? My contracts don't state anything about being impaired on the job. Is this an implied term, or should it be written into employment contracts? So I don't think it's ever really a bad idea, of course, to put stuff in writing, make it extremely clear. But in a case like this, there is also an implication that you're not going to show up to work intoxicated, inebriated, under the influence of something, especially if it affects your ability to do your job, and especially if your job is one maybe of a more safety sensitive position. So I think you're within your rights to make some inquiries about this, though you do want to be careful. Sometimes I'll bring up a case I had in the past. There was a situation where I represented a truck driver, and he was caught going over the border, the US border, with some marijuana, and he actually got a criminal charge. His employer found out about the criminal charge and basically asked him, what's going on? What's this I hear about you getting charged? And it also had to deal with marijuana. And my client at the time had told the employer that he had a problem in terms of his drug use or his dependency on that. And he told his employer that he had a problem, and it was clearly bleeding into the work relationship. It was sort of spilling over into the work relationship. And the employer found this out and let him go. But because he mentioned it was a problem that was affecting, that sort of spilled over into the workplace, my argument was that his employer should have made some more inquiries before letting him go, because you start to get in the realm of accommodation. If someone has a disability, say, for instance, they're an alcoholic, and you become aware of this, or you make some inquiries and find this out, to terminate that person on the basis of being drunk at work when you know, or ought to know, they have an addiction, that can actually be seen as a breach of human rights. And it's understandable why a company would want to let somebody go like that, but you need to be very careful if they've said certain things, or if you've made certain inquiries and they mention as much in terms of terminating them, because you could actually be on the hook for a human rights violation. You might end up owing that person their full severance, plus potential human rights issues. So in these cases, number one, I think you should give us a call. We do a lot of work for employers as well. And in some cases, it's actually required that the employer either make further inquiries about this substance abuse or use, and also potentially accommodate them further to the human rights issue. So in the trucker example I gave, one thing that I think the company should have done, instead of terminating him, or at least before terminating him, was to deal with that issue that he had, the abuse issue, in terms of maybe having him attend certain meetings, or going to like recovery sessions, or getting rehabilitated, essentially. And that's where I say that there would be an obligation in a lot of cases for employers to try to accommodate by way of offering some sort of rehab or course or something, so that you're not letting somebody go due in part to this substance abuse issue. Because even if 1% of the reason that you let them go had to do with this disability, so to speak, then, as I say, you're going to open up a huge can of worms. So you want to be very careful about this before pulling the trigger. You want to make some inquiries and potentially take certain other steps to try to accommodate, as frustrating as that may sound, just because the ramifications otherwise could be way more than you were thinking initially. But I think in this case, Nadia, I definitely think you should give us a call so we can kind of get a full background on, what it was you noticed about the behavior, how exactly it was affecting his work, what exactly he communicated to you as far as his substance use is concerned. And then I think from there, we can get a better picture on how to sort of plan it step by step so that at least you're crossing all the T's and dotting all the I's. And so that if it comes to a point where you are going to or do need to terminate, you can at least satisfy potentially to a court or an outsider that you canvassed other options and that you at least fulfilled the obligations on your end to the extent they exist as far as accommodation and all that sort of concerned. But, in general, to your first question, again, that is an implied term, but it just comes down to a more case-by-case basis as far as whether there's an addiction, what's been communicated, et cetera, just before pulling the trigger, so to speak. So give us a call. I would highly recommend it, Nadia, but I do appreciate the question. I know it's sort of a tough spot to be in, especially as a small business owner. I've got another question in from Rodriguez on Facebook, who's saying they work in a dental office, which is now a corporation, and they've noticed some illegal billings. And when they brought it up, they were written up twice for it. They're saying that they're breaching code of conduct because they're questioning the dentist, but rather they believe they're just obeying the law, bring it to their attention, and now they've been put on progressive discipline, maybe some sort of performance improvement plan. So first of all, your employer cannot retaliate against you as far as you bringing forward valid concerns, especially concerns that are violations of the law. If someone has reason to believe that there's stuff that's illegal going on, I guess one option, they could go to the Ministry of Labor, but also if they bring it up to their employer, retaliation is just simply a no-go. I'd be curious to know why it is they're saying you're breaching the code of conduct just by virtue of questioning the dentist. But it does seem to me like there's retaliation here. You're now being put on progressive discipline, possibly being threatened that your job will be gone if you don't meet certain standards or metrics based on this performance improvement plan or whatever it is that you put on. So from looking at it on its face view, it does seem retaliation is there. There are reprisal laws in Ontario that specifically look to protect people who bring forward complaints. So whether it's a complaint about illegal billing or practices, maybe someone brings forward a complaint that they're being harassed or bullied. A lot of times when that happens, they then find themselves without a job or getting some pushback from the employer. But that's all going against the reprisal laws in Ontario, which are supposed to protect people so that they can come forward with these complaints knowing that they're not going to be retaliated against, because if not, then everyone would just be quiet, nothing would be said, and obviously there would be a much more toxic work environment going on there. So that's sort of partly the reason why these laws and regulations are put into place to begin with. So Rodriguez, I would definitely in this case also tell you to give us a shout, set up a consultation, as far as going through what the illegal billings are, what exactly you're written up for, what they're referencing when it comes to breaching the code of conduct, and also looking into this progressive disciplinary stuff. You may be in a situation where you'll have the ability to actually leave your employment as though you've been terminated and go after this company for full severance and potentially other damages, going further to the reprisal and the retaliation that I was talking about. And it seems like you're sort of getting a bit of an agreement with the Dental Association. So yeah, it definitely seems like a big issue that this dental office is looking like they're just trying to brush under the rug, and they could be opening up a huge can of worms by doing all this, and you could have potentially significant entitlements. So give us a shout. We'll walk you through what to do and whether or not we need to get involved on a more formal basis and hopefully either resolve the issue or at least get you out of there with a fair package and then some. But thanks Rodriguez for your question. I'll answer one more. We've got a little bit more time. I'll answer one more question from Delia on YouTube, who's saying, if an employer completely changes your jobs and puts you in a different department, but the grade level is the same, but you no longer have direct reports, does this constitute a constructive dismissal? And absolutely, it can certainly constitute a constructive dismissal. When you say completely changes your job, I mean, that sounds quite significant. A constructive dismissal is when significant changes happen to your job that you don't agree with. So it could be the case that your grade level is the same, maybe your pay is the same, but as you say, you don't have anyone reporting to you now, which you could argue is a loss of responsibility or prestige or seniority. But also, of course, being put in a different department, I assume that your duties and responsibilities in general are going to change. So your actual day-to-day job might be vastly different. Again, even if the hours are the same, even if the pay is the same, your actual day-to-day job is vastly different. That alone can constitute a constructive dismissal and may give you the right to basically take a stand and say, no, I don't agree to this. I agreed to this. This is what I signed up to do, ABC. And now you're telling me without any input from me that now I have to do DEF, no longer ABC. Before you object in writing, I would say give us a call as well. But usually it starts with putting that in writing, objecting to your changes, stating that they are significant, detailing how so, and saying essentially that you're ready, willing, and able to do the job you had, to show that you're not being completely unreasonable, but that this is not what you signed up for. This is completely different. It's like day and night. And to basically have them confirm if that's the only option that they're giving to you, because if so, you may have to review and consider your options moving forward. And then depending on how they respond, the ball being in their court, they might give you your job back. But if not, and they insist that, essentially it's our way or the highway, well, now you've already put in writing your objections. You've given them a chance to correct it. Maybe you've given them a little time to fix things. Still not happening. Then usually at that point, a lawyer can step in, claim that there's been a constructive dismissal, and essentially look to get you your full severance entitlements, just as though they had let you go without cause. One more question I'll answer from Carlos. I see it here on Facebook, who's asking, if your employer renews your contract, do you lose your years of employment? And generally speaking, the answer is no, you don't. So a lot of times people may have a new company come into the picture who has you sign a different contract, but you worked for the old one for 10 years, let's say. You're going to be viewed generally still as an employee with 10 years plus whatever you've got with the new employer. You do want to be mindful, though, when you're signing contracts, that there's nothing in there that says you forfeit any previous seniority with the former company, or you waive any of that service or that tenure with them. Definitely want to be mindful of that. But no, generally speaking, you don't lose it. It keeps getting accrued. There are other situations where you may sign a number of fixed term contracts. So you may sign a contract maybe for a year or two, and then that one expires, and then you sign another one for a year or two, and then another one for a year or two. Usually in those scenarios, the same logic applies. You're not going to be seen as just a 1 or 2 year employee for each contract. It's going to add up altogether. Again, unless there's some sort of special language in the contract that looks to limit that seniority that you had. But otherwise, no, it would just keep building up, and you would just be assessed as having, whatever number of years plus the ones you had before the renewal of the contract. But again, keep in mind with what the contract says. Maybe give us a call, get us to look at the contracts that you're talking about, just to make sure that you haven't signed something already that could affect your rights, and of course that you're not going to sign anything in the future that does that. So hopefully I answered your question there, Carlos. But thanks for bringing that in. That'll do it for my time today. I'm happy that I was able to answer everyone's questions, but for those that may have questions that have not been answered yet, definitely tune in. We've got these things going on all the time, as you see down below there. This Friday, August 2nd, Teelan will be available to answer all the same types of questions that I am. But again, thanks everyone for showing up today. I appreciate your time as always, and I'll definitely be back to do this again. So stay tuned. But otherwise, do enjoy the rest of your day. Have a good one. Take care. Bye.